Once all of its assets are distributed, it just goes off into never, never land, never to operate again. So there's no, you can't go collect against the defunct company. If Mr. Smith was liable to you, and he filed bankruptcy, and you came in and appropriately filed a complaint under Section 523, saying he committed fraud on you, or he molested you, or something like that, one of these grounds that are within the guidelines, and after a verdict or by agreement they said this debt is non-dischargeable with a trial, then you get to go after Mr. Smith's future income. His future income is non-dischargeable. Consolidated Freightway has no future income. Its money is in a pot for the benefit of creditors, period, and when the creditors all determine, the pot will get dissipated to zero. Okay? Less paying all these attorney's fees that we're incurring. So your claim today that triggered the cost has affected all your fellow employees by whatever that cost is. I want you to be careful in the future because you're costing your employees money.
Your Honor, to that point, I just wanted to inform the court that responding to Ms. Koski's various claims has already cost the estate over $100,000 in attorney's fees, and I appreciate your kind of sanctioning Ms. Koski this afternoon to the fact that this is very costly to the estate and to debtors' other creditors.
At the end of the day right now, Ms. Koski, this is what I want you to understand. I'm giving you a right to pursue your injury in one place. But it's got to be you got to understand, whatever you get is going to come strictly out of the hides of creditors, because you're going to share it as a pot. The biggest creditor body are all the workers. I protected them more than anyone else, either in their underpaid PBGC claims, the Warnack claims that remain unpaid, the pension fund claims from the union claims. They're the biggest creditors in this body. Administrative expenses by law get paid first. That's why I'm so tough on them for objecting to claims that don't have merit to it or are so small. I don't want to spend $1,000 to save $500. I'm not letting them do that. I'll take it out of their fees. So the same warning I give to you, if you file an amendment, you better have all your ducks in order, because what you're doing is making the lawyers spend money that's coming out of the backs of the unsecured creditors. That's all we got left to pay once we ferret all these problems out. And some of them are much bigger, in my mind, than your individual problem. Okay? I'm making a hard decision about whether 3,000 retirees get priority claims. That's a $13 million question. But it involves 3,000 people. Okay?
Yeah, I appreciate you explaining this to me. And just on defense of myself, I've tried with numerous lawyers to get answers and paid them, and I've received, misrepresentation, and so it's been quite difficult.
All right. At this point, from the claim standpoint, you need to understand, in this case, you have one remedy of a substantial nature left. Make your case in district court, or you're done on the big claims. Don't even come and bother me anymore on that. Other than the 994, if you can attach records to support your position. Unpaid medical bills that were incurred, hard data, because they will have a clerk look at that who will sit down and say, this is pretty close, and they'll either allow it, just not object to it, or they'll object and state why. But then it'll be done by someone who's appearing by phone and isn't going to be expensive like they are in your case. Not too many people file multi-million-dollar claims. Okay?
Okay, thank you very much.
Good luck, ma'am.
Thank you,
Claim
Your
is
Honor.
disallowed without prejudice. Is disallowed with prejudice, except, Ms. Koski, I want you to understand, the amended claim is disallowed with prejudice, because you already got a claim on file, with prejudice, except the right to file an amended claim, the right, not the absolute duty. You got to dig up the records for up to the $994.64 based upon supportable documentation. If you don't have the records, don't file the claim. Okay?
Yes, I understand.
All right.
Thank you, Your Honor.
Then will be disallowed with prejudice, except Ray, priority right.
On the situation here, that law, non-dischargeable debt for intentional, willful, malicious acts, I don't believe these corporate Hitlers get to go to heaven, as the judge is indicating. He's saying the Supreme Court came down with a law just prior to me bringing my suit. What happened was I marked the box in bankruptcy, the unsecured, and then I found the case law and it should have been secured. Drunk drivers cannot declare bankruptcy after they've damaged you and just think they can declare bankruptcy. Corporate Hitlers, though, as this judge is saying, it is up to his discretion, and he believes a different stance. It's quite, I think the forms in the bankruptcy are defective, because you have secured, unsecured, and then you have secured, priority, and unsecured, and obviously there's a lot of issues being addressed when this happens. Bottom line for me is, I received death threats from this corporate Hitler. All of a sudden my truck gets launched over the cliff by my coworker, who, you know, really didn't have background checks on him, and so this to me, and not alone, Arthur Andersen did the books, the accounting firm for Enron, so, you know, they're real do a lot of tricks. And then we already had Emory, the pilots, they won $500 million, and they said the same thing as union reps as I was, that, you know, the company was basically trying to get rid of the unions. They had DC-8s falling out of the sky and 747s. One almost killed 300 people at an auction yard. They left an hour before the plane crashed, put a hole in the ground. And the union just left us, even the Emory pilots. They had to go get a family law attorney, you know, so you can imagine the amount of pressure that was on him. He did a good drafting, and I used it as a course of conduct for my cases. I'm still into it. And however, you know, my situation, even with top dog, world-class attorneys, top notch, I hadn't had any luck. You know, we couldn't figure out, you know, here they were alleging they were self-insured, and however they weren't. And unfortunately, I still feel the world-class law firm that I did hire on my appeal and won, cost me $50,000, should have continued to help me out, because they're making they've had judgments of billions of dollars that they've made, and if they don't help out the little guy, then this is what happens to an injured individual. And it's been quite a struggle for me, and it basically destroys your life, and there's no reason for it, because the evil people are getting away with this, and they should not. Latham and Watkins should have returned the phone call. You know, it called her 3 times to get on the, you know, this medical bill for having, I had a few of my teeth knocked out, you know, and I was getting stuck for the medical bills and whatnot. And she never called back. And sure, I lost it. It's confusing for me. I've been disoriented from the whole thing. But, you know, of course, I'm going to stay in the fight and do everything I can to prevail. And I will prevail. And at least everybody else and the attorneys have a heads up now with YouTube, allowing us to relay information.